So, good morning. On behalf of all the speakers today, I'd like to welcome you to the first of a series of webinars which will be organized by Fenech and Fenech over the coming weeks and months. As you know, during this webinar, we will be exploring the importance and implications of board meetings during this particular period of history we're living. I'll start by introducing our panelists today, Sarah Grima and Maria De Bono and myself from the Corporate and Commercial Department of Fenech and Fenech Advocates. We will be exploring the corporate legal implications of directors at their meetings. Sarah Rousey and Rebecca Diacono from the Legal Tax Department, who will explore the tax implications arising from the directors' meetings. And finally, Carl Diacono and Adrian Merchea from Fenech's Corporate Services, who we invited specifically to answer some of the practical questions we received on registration and others based on their vast experience as directors on a number of boards. Seeing that this is a rather legalistic subject, I'm going to be sharing some slides with you. So that we can follow the presentations better. As you all know, COVID-19 has brought with it a variety of challenges, especially in the business world. Today, we will try to answer some key questions, such as how are directors effectively conducting their decision-making processes, and more importantly, what has changed during this eye-opening time of lockdown. How can decisions still be effectively taken while adhering to the social distancing requirements, which in spite of the lifting of measures will probably be with us for quite a while? The implementation of these measures should not mean that directors should postpone their board meetings to another day. On the contrary, it has become even more important to be able to schedule meetings with management on a regular basis, so that directors can be kept abreast of the company's day-to-day financial and operational position, as well as providing updates on the government regulations affecting the business and the measures being taken by the company itself, of course. On this note, this webinar is intended more or less to provide a brief outline of the role of directors in the company, as well as practical solutions and considerations which may be implemented at board level, basically, to ensure that board meetings, even if they are held at a distance, are still carried out effectively and appropriately in light, in particular, of Maltese law. We have also tried to set out suggestions based not only on our practical experience, but also on recommendations by local and foreign literature, which we feel may come in handy in the current circumstances. You will note that on applying for this webinar, we gave you the opportunity to send us the questions, which we have tried our best to answer as we go along during the course of the presentation. You can also use the QA function at the bottom of your screen, and if any questions remain unanswered, we will do our best to actually get in touch with you by email. In any case, at any point, feel free to drop us a line should you need more help or have some questions. Our general email address is webinars@fenlex.com, or else later on during the presentation, you will see our personal email addresses, and obviously feel free to contact us. So to start off, by way of introduction, Dr. Sarah Grima will start at the very beginning, as it were, by outlining the salient responsibilities of directors under Maltese law to set the picture. This outline should emphasize the central role which directors have in the running of companies. On to you, Sarah.
Thanks, Krista. So to begin with, I will be going into the general duties of directors under Maltese law. Directors of a company are duty-bound to promote the well-being of the company and are responsible for its proper governance, administration, and management, essentially. The general rule is that directors owe their duties to the company on which board they sit, and not to, therefore, the shareholders as such. And this is often a question asked by our clients. What control can the extra shareholders exercise over the decisions that the directors can take? Can they impose their way in practice over certain decisions of the directors? And the clean and simple answer is no. In carrying out their duties, directors should not be influenced by the power that any shareholder or a class of shareholders may have over the appointment, replacement, or removal of a director. Directors should be able to discuss and be informed of all matters concerning the company so as to be able to assess each matter on its own merits before taking any decisions. And they should effectively be able and feel comfortable to question suggestions put forth by members of management and by the chairperson himself. And where necessary, directors should also seek advice from external professionals on any matters of which they may not have the adequate competence or the adequate experience in. What is ultimately the most important is that directors make an informed decision and not simply ratify decisions which may have already been taken, therefore, without possibly their prior deliberation. And this is especially so, seeing as directors can ultimately be held personally liable under Maltese law, which is something we will delve into a bit later on in our webinar. So the duties of directors are very far-reaching. They're quite broad, and the Companies Act actually provides a very general duty of the directors to be that they must act honestly, in good faith, and in the best interests of the company. Directors are specifically obliged in terms of law to exercise the degree of care, diligence, and skill which would be exercised by a reasonably diligent person having both the knowledge, skill, and experience that may be reasonably expected of a person carrying out the duties of a director in relation to the company, and also the knowledge, skill, and experience that that particular director has. So before appointing an individual to act as a director of the company, the shareholders should ideally ensure that this person has required level of integrity, skill, and knowledge to act as a board member on the board. And in the same way, directors, before accepting any such appointment, should assess the business of the company to ensure that they are adequately skilled to take the company forward. And it would also be prudent for directors to assess the other members who make up the board to ensure that there is adequate expertise across the board. In regulated entities, this assessment is actually often independently carried out by the regulator. For example, the Malta Financial Services Authority or the Malta Gaming Authority. This notion of skill and competence becomes even more relevant in light of the fact that the law specifically imposes other more general duties on directors. For instance, the duty not to make secret or personal profits from their position without consent of the general meeting, not to use property or information of the company for their own or anyone else's benefit, not to act in competition with the company, to avoid conflicts of interest, to declare personal interests in transactions with the company. And most importantly, or one of the most important, is that directors must act within the remit of their powers. And this emanates essentially from law, from the Companies Act, but also from the company's M&As. Directors cannot act in any manner or enter into any transaction which is first and foremost against the law, but also which goes beyond the company's objects in terms of the M&As. So directors are first and foremost bound to observe any limitation on their powers. Now, as to what sort of limitation may be imposed by the M&As, this is quite tricky to answer, particularly because directors, in terms of the Companies Act, include any person occupying the position of a director of a company by whatever name he is called, and carrying out substantially the same functions in relation to the direction of the company as those carried out by a director. And in certain instances, the Companies Act goes so far to state that a director can also include any person in accordance with whose instructions the directors of a company are accustomed to act. So essentially, while there's no doubt that the persons formally appointed as directors, of course, are entrusted with the duties and the powers arising from their office as directors, there may be instances where other persons who are not formally appointed as directors could ultimately be subject to the same duties and therefore exposed to the same liabilities should they be in breach of these duties as directors proper. And these are, we normally refer to them as shadow directors. And this could be, for instance, a shareholder who is carrying out in practice the same function as a formally appointed director. So on this point of directors, the limitation of directors' powers, it's also important to say that while the MNDs may impose limitations on the powers, these limitations cannot be relied upon against third parties acting in good faith, which means that if directors were to enter into a contract on behalf of the company with third parties acting in good faith, which contract it transpires may effectively go beyond what is permitted by the MNDs, the company is ultimately still bound to honor this contract. And this is because the law presupposes that third parties are not obliged to verify whether the contract in question is within the company's powers or not. This is always the responsibility of the directors. Now, besides the general and fiduciary duties of directors, the Companies Act also regulates a number of instances where directors and officers of the company are subject to other more specific duties, which may be broadly categorized into three. So there are those statutory duties which emanate directly from the Companies Act and which apply throughout the company's lifetime. There are additional duties which are imposed in relation to a possible pre-insolvency scenario, and then there are those duties which are applicable in the context of actual insolvency. I won't be going into these duties in detail for the purposes of this webinar, but we've prepared a couple of slides which provide a high-level outline of these duties, simply to highlight the importance of the director's decision-making process. As you can see, the statutory duties imposed by the Companies Act on directors range from the duty to keep proper registers, the duty to appoint the auditor, to approve the accounts, and so on and so forth. These duties, as I said, are imposed throughout the course of the company's lifetime, and therefore they apply regardless of the state of solvency of the company. Of course, in the instance that companies are facing possible insolvency, there are additional duties which are incumbent on directors, and we will go into these a bit later on in our webinar when we discuss the practical considerations that directors may wish to consider in a crisis situation. I know I have quite a lot to discuss still, so I will stop here, but I just wish to mention one last point regarding the director's duties, and that is that directors can be also considered as agents of the company, and in terms of multi-civil law, a mandatory, being the agent or an attorney, is answerable not only for fraud but also for negligence. So it is extremely important to bear in mind that a director is expected to act in good faith and in the best interests of the company at all times, as otherwise he may be held liable for fraud or negligence.
Thanks, Sarah. That was very informative. So basically, as Sarah outlined, directors are key in the daily running of a company, and so their decisions will inevitably impact the direction towards which the company is steered. Now, Maria and I will explore the manner in which these decisions are typically taken. As most of you probably know, in general, directors take their decisions by means of resolutions decided upon during board meetings. The law also, however, allows for resolutions to be taken in writing, and this option becomes even more attractive when boards cannot physically meet, like in the current situation. So while the holding of a board meeting is a matter of good corporate practice and should definitely always be encouraged at least a certain number of times a year, it may not always be possible or even efficient in the best of times to wait for a meeting to take certain decisions of which everyone's in agreement. So the main restriction basically imposed by law with respect to board resolutions in writing is that all directors must unanimously agree and therefore sign this resolution. So basically, in this case, majority voting doesn't apply. So everyone has to be in agreement. related to this aspect is that of actually obtaining signatures. You may have experienced in the past weeks how tricky this can be, especially when movement is impaired and meeting is not always easy. So it's recommendable now, especially to check the statutes of the company to ensure that basically they allow for round-robin signing so that you won't actually have to sign the same document. And electronic signatures. Though technically this does not specifically need to be stated in the statutes because it is allowed and specifically recognized at law in most cases, it definitely would add clarity when it comes to interpreting the statutes that such an inclusion is actually made. Before concluding on resolutions in writing, one last point regarding delegation of authority. Seeing that movement was restricted, as we said, over the past months and may remain somewhat limited in the coming months too, in spite of the lifting of measures and this new normal, it's a good time to see what attorneys the company has actually appointed and maybe even to consider whether to terminate certain appointments or possibly even increase them for specific reasons and for added efficiency. Having attorneys present in key areas of business to sign documents may help speed up processes and transactions, especially because travel bans will, as we said, still be imposed in multiple jurisdictions. And although they're slowly being lifted, they may be introduced later on should the situation spiral again. So it's always best to be prepared, as we saw. Directors should also remember that the statutes themselves include an appointment of a legal representative appointed to represent the company by the shareholders themselves. So this may be a good time to explore whether to recommend to the shareholders to actually appoint additional legal representatives, possibly, and to reconsider whether those so appointed are actually being effective in carrying out their role. Also, finally, one last point. Now, at this point, communication is key. So we also suggest that directors try to get even more regular updates on the actions of representatives and attorneys, so that they keep sort of abreast with what they're actually signing and entering into. Okay, so moving on, now Maria is going to provide some more detail on the main matters to consider when holding a physical board meeting. Maria.
Okay, thanks Krista, and good morning everyone. So as Krista mentioned, what I'm going to focus on now is board meetings in general and what same require, if anything, at law. So first of all, how does the law regulate board meetings? So while the Companies Act goes into considerable detail in connection with general meetings of shareholders, there is very little regulation on the manner in which directors' meetings should take place in the best of times, let alone in a crisis situation when physical meetings, as we know them, are no longer possible. For example, I would just like to briefly mention that notably in terms of general meetings, a few weeks ago, a new bill was published called the Companies Act Amendment Bill, which has actually allowed the minister to make regulations to suspend any periods of general meetings of shareholders and to also make regulations for the potential holding of virtual annual general meetings and other meetings in light of the current crisis. However, board meetings do not seem to be mentioned or catered for within the bill. So absent this detailed regulation, most of the direction in terms of board meetings is given by the schedule to the Companies Act, which sets out the model regulations for limited liability companies. It is then up to the shareholders who are adopting the first articles of association to draft the first regulations which directors need to follow when regulating and holding their meetings. However, generally, directors are given quite a free hand in the articles to regulate their meetings as they deem fit. An important point, however, to keep in mind is, as we saw earlier, as Sarah mentioned, directors should be acting in the best interest of the company. So their meetings should be regulated with this premise being borne in mind. Secondly, is there a need for board meetings and or a duty to attend and participate in same at law? So as we said earlier, while there is no express statutory requirement at law to hold and attend any specific number of board meetings each year, directors of a company are bound to promote the well-being of the company, must act in its best interest, and are responsible for its general governance and proper management. Therefore, in view of this, it stands to reason that this need to hold board meetings stems from the fact that in order to take important and effective decisions, directors need to discuss and meet and share ideas before coming to the right decision collectively. Still, this is obviously qualified by everyday realities in that a director need not attend every single board meeting or participate in every transaction discussed and decided upon at a board meeting. In practice, we have largely seen boards which meet twice a year as a minimum, some boards which never actually hold physical meetings and rely solely on written resolutions, and others which hold more meetings than is customary, especially during challenging times such as these. Often, the regularity of these meetings is driven by tax considerations and also if it is imposed by regulations, for example, in the case of licensed entities. The next question is if there are any main matters to be discussed at such board meetings. Again, the law does not specify any matters to be discussed during board meetings, but there are certain basic minimum requirements, such as the approval of accounts and the recommendation of dividends, which fall within the director's responsibilities and powers. And these must therefore be discussed and resolved upon annually. Now, how are meetings convened and what about notice of such meetings? So Article 62 of the model articles provides that a director may and a company secretary on the requisition of a director must at any time summon a meeting of the directors. So if you're a director sitting on a board right now and no meetings have yet been convened, now might be the right time to do so, to discuss the impact that the current situation is having on the company and its business. In terms of notice of the board meeting, generally notice has to be given to all the directors on the board, and the Companies Act, however, does not stipulate the notice period required. This makes sense because urgent matters may occasionally arise, which would require directors to meet imminently and without time to give such prior notice. So the matter concerning notice is generally determined by the Articles of Association of the company. Another point I would like to mention is that while this is not obligatory, it is a matter of good practice that notice of a board meeting would include a formal agenda and a copy of the documentation that is to be discussed at the board meeting. This is so that directors can effectively prepare themselves ahead of the meeting. The next question is the quorum. So how many directors need to be present at a board meeting? So in order for a board meeting to proceed to business, a quorum must be present. And this, again, is generally determined by the Articles of Association of the company. Of course, there may be a situation where a quorum is present at the time when the meeting commences, but some directors might leave while the meeting is being held so that no quorum effectively remains. And in this instance, the meeting should be adjourned. Next are the minutes of the board meeting. So what does the Companies Act require? The Companies Act requires every company to cause minutes of all board meetings to be taken and to be kept in minute books. We will discuss this later when we talk about practical considerations, but essentially minuting decisions becomes even more important for directors when they may be facing a situation where they have to justify their decisions, especially should they be faced with an insolvency scenario and in particular claims for wrongful trading. Now, Krista will proceed to give some information on the possibility of recording such board meetings and whether this is in fact possible.
Thanks for that, Mar. That's it. One final consideration we wanted to make was regarding the actual recording of meetings. Basically, can meetings be recorded without the express consent of the directors or persons attending? Seeing that many board meetings due to be held or which will be held later on this year may need to use online platforms, the possibility to record such meetings becomes very often easier and more accessible. But can such meetings be recorded without the express consent of the directors and the persons present? And can a majority vote taken by the directors be equated with this consent for all? And the brief answer to that is simply no. A director or any person attending a meeting becomes a data subject. And this means that as a data subject, they cannot have their personal data processed simply because the majority so decides. So ideally, together with the notice, or if for some reason this didn't happen at the very outset of the meeting by the company secretary or the chair, these should ask whether all persons present on the online platform for that particular meeting give their consent to the recording of the meeting. They should specify that any objection should be stated clearly at the start of the meeting. As I said, it would definitely be cleaner if together with the notice, a specific consent form is sent, which can be filled in and signed and filed. But otherwise, it will need to be stated. The company secretary or chair should also specify the precise reason or purpose behind the recording of the meeting. For example, preparing transcripts, which is possibly the most common reason for recording the meetings. And in such case, it should be explained that once the transcription is complete, then the recording will be deleted. They should also specify that the recording may not be accessed or used for any purposes which go beyond the purposes of record keeping for that particular or future board meeting. So the persons present at the meeting should also be made aware of how long the recording will be kept and the right to actually access it. Unless the consent form or the consent obtained during the meeting and clearly minuted squarely stated that all future board meetings will be recorded and everyone present accepted and will be present at the next meetings, then the consent should be interpreted narrowly for just that particular meeting. In conclusion, it is very important that the consent is in a fixed format, so written, email, etc., something which can be proven down the line. As I said, minutes should therefore be fine. The subject, again, can take up a whole hour on its own, but we thought we should highlight this aspect, saying that it's very topical, and we feel that directors and company secretaries should be aware of the importance and legal significance of obtaining the necessary consents before the meetings are recorded. Before concluding this first more legalistic part of the webinar, Sarah and Maria will now be addressing some questions which have been raised in connection with board meetings, and we should be able to provide some practical pointers in this direction. I'll start with you, Sarah. What do you think are the main clauses which need to be considered in the M&As in the circumstances, if any at all, actually?
Yes, definitely. Directors, first and foremost, should seek to review the company's M&As to see whether the M&As effectively cater for the possibility of holding a board meeting remotely. It could be that the M&As are silent on this point, and it could also be that they expressly forbid meetings to be held remotely. It is generally accepted that unless the M&As specifically and expressly prohibit virtual board meetings to take place, then meetings may be conducted by telephone or video conference or any electronic means. And it is very unlikely that the courts would not uphold an otherwise validly held meeting, which would be conducted by electronic means, especially considering the social distancing situation we have found ourselves in. So, of course, but in order to eliminate any doubt, if the M&As are silent on this point, and definitely if the M&As specifically prohibit M&As, remote board meetings to take place, it would be advisable to amend the M&As, which requires an extraordinary resolution of the shareholders. And this clause, which may need to be amended or added to the M&As, may cover some practical points. For example, that the directors can effectively, the directors attending the board meeting can effectively hear each other well, can speak clearly, and hear themselves. It could also include that the number of directors be not less than the required quorum, for example.
That's it. So related to this, in practice, how can participation in remote meetings effectively take place?
Okay, so obviously, as a starting point, it's important to consider the means of communication to be adopted, whether it's going to be by video conference, whether it will be by telephone conference, the system to be used, there's quite a lot out there now to choose from. It would also be advisable that IT support is available and accessible during the remote board meeting in case the connection might drop or there's a technical disruption to the meeting. What is important is that the directors can effectively engage in the meeting as they would in a normal physical boardroom. So this means that they must be able to speak and to be heard clearly and equally to hear others clearly. On this point, I suppose it would be more reliable and suitable for large boards to hold audio-only meetings rather than video meetings. Now, regardless of whether the meeting is held remotely or physical, the requirements for a properly constituted quorum must be met at all times. So this means, as Maria has gone into as well, that if there is following, if once the meeting starts, there might be a disconnection, or the link drops, the communication line is disrupted, which effectively impacts on the quorum. Therefore, the meeting should be adjourned, and no resolution should be passed at that point. And the meeting should be then reconvened to another time when all communications are working efficiently again. And any of these occurrences, the adjournments, the disruptions, the resolutions being passed or not passed, must of course all be minuted. Another important point is the chairman. So the chairman, even in a remote board meeting, should actually take control of the meeting as he would in a normal physical boardroom. Directors must of course be able to debate, they must be able to vote on the matters at hand. All efforts should be made to ensure that each director has an opportunity to contribute to the meeting, and of course to give his or her consent on the motions being passed. Now, to avoid any confusion or misunderstandings that may result from, for instance, a show of hands in a video call, the chair may wish to ask each director in turn for his or her vote. The chair could also use the mute and unmute functions to ensure that each director gets a say, and it's clear who is saying what, and what resolutions are being passed and what consents are being given or otherwise. Directors may also wish to consider the voting software that maybe the platform allows for to make the voting process easier. Possibly another relevant point to mention is that even at remote board meetings, proxy may still be given. So a director may validly give proxy to another person to attend the remote board meeting on his behalf, of course assuming that the MNBs allows for this.
That's it. Thanks. So, Maria, Sarah has just emphasized the need for clear and efficient communication and coordination of remote board meetings. Can you go into a little more detail on the role of the chair and the company secretary in this respect?
Yes, of course. So proper coordination is always key for any board meeting, remote and otherwise. And as Sarah said, various IT tools and various channels of communication are being promoted at the moment. And this may lead to a sense of confusion when it comes to coordinating the meeting and ensuring that it runs smoothly, especially if all the directors are not used to holding such remote board meetings. So the two key roles to consider in this task of ensuring proper coordination of the board meeting are that of the company secretary and the chair of the board. I'll start with the chair of the board. Although it is not specified at law, in practice, crisis management demands that the chair takes on a leadership role with respect to the board and its management. So the chair must essentially keep the board united in its approach, ensure that communication between members is effective, and that the meetings are regular, ensure that committees, if any, continue to discuss ongoing matters that they are typically entrusted with so that regular business continues to flow, consider setting up new subcommittees, maybe for specific discussion on crisis-related measures to be taken to ensure effective channels of communication between committees, board, and top officials of the business like the CEO, to also update the shareholders as necessary on discussions and decisions of the board that the board has taken during this crisis. However, still ensuring that the board is the main decision taker when it comes to the management and actually running the business. And to also liaise with the company secretary, especially in connection with minute taking and the circulation of the minutes. So the company secretary then, despite the name, is not merely a secretarial role. And according to the Companies Act, it is not permissible to incorporate a company without having a company secretary appointed. So the company secretary does not engage in the management of the company. However, it is essential that the company secretary engages in active dialogue with the directors, who the company secretary keeps informed of their legal responsibilities. Engagement with the board is also important to sufficiently plan in advance of any virtual meetings to ensure that the meetings are conducted as smoothly and efficiently as possible and to limit the risk of anything going wrong or remaining unclear on the day.
Agreed, Mar. In this line, in line with this discussion, basically, of the company secretary, as you mentioned, the importance of meetings comes to mind. Any tips on this?
So essentially, minutes, it is imperative to record accurate and detailed minutes of all board meetings. including the discussions that have taken place and the reasons behind the adoption of such decisions. The approval process should also be recorded in full, including any disputes which may have arisen during the board meeting, and the minutes should also indicate the name of any director who may not have approved of the final decision taken. Of course, during this pandemic, which has restricted the possibility of physical boardroom meetings, the importance of proper minute taking is heightened. In addition to what was said before, minutes of remote meetings should additionally expressly confirm that the board meeting has taken place via electronic means, and should ideally state the enabling provision in the Articles of Association, if any, that regulate such remote board meetings. As a matter of good practice, draft minutes of each virtual board meeting should also be circulated to each director following the meeting to ensure that there is agreement by all in attendance and that the minutes accurately reflect the business transacted at the meeting. The minutes should also be signed by the chairman wherever he is physically located.
Thanks. Finally, to conclude, is there any specific guidance on the frequency of board meetings, especially in a crisis situation?
Okay, so as we said earlier, the law does not expressly enforce a minimum number of directors' meetings to be held annually. However, as we mentioned, regular board meetings are vital to ensure that the business remains resilient to immediate challenges as well as long-term challenges which could arise from the COVID-19 pandemic. I think at this stage, it's important to make a distinction between the situation where the company is solvent and when it is insolvent, or at least is veering towards an insolvency. This especially considering the potential personal liability which may arise in terms of the wrongful trading provision, which may be enforced against directors when a company is being wound up. So as Sarah mentioned earlier, certain duties on directors kick in when a company is veering towards insolvency, primarily on becoming aware that the company is unable or imminently likely to become unable to pay its debts. The directors of the company are obliged by not later than 30 days from when the fact became known to them to convene a general meeting of the company to be held within 40 days from the date of the relative notice. This is for the purpose of reviewing the company's position and to determine what steps should be taken to deal with the situation. This would necessarily include consideration, but no obligation, obviously, to put the company into dissolution and consequent liquidation, or whether the company should file a request under the company recovery procedure, for example. So now more than ever, I believe directors must monitor and assess even more regularly than before the position of the company and the financial position of the company to ultimately ensure that the company they manage is not insolvent or likely to become insolvent anytime soon. So on this note, the need for increased meetings, of course, becomes much more significant. So directors are always duly informed on the financial position of the company. As we said, the need for increased meetings and proper minute taking arises especially in the context of directors facing a potential wrongful trading claim. Indeed, if it is shown that the directors of the company knew or ought to have known that there is no reasonable prospect that the company can avoid insolvent liquidation, in such case, a court may declare the directors personally liable to make payment towards the company's assets as the court deems fit. In this scenario, the director's sole defense to such a wrongful trading claim is whether they have taken every step to minimize any potential loss to the company's creditors. This therefore brings me to the point that in light of this sole defense available to directors when facing a wrongful trading claim, then evidently having a proper paper trail which shows that the board has met frequently, albeit remotely, to discuss and keep themselves duly informed of the company's financial position becomes very important, as even if the company does end up in an insolvent liquidation, the directors would be able to show that they took the due consideration of the company's creditors and financial position when deciding on certain matters and transactions. Therefore, in sum, and to answer your question briefly, yes, directors should insist on regular board meetings so that they are always kept abreast of the financial position of the company, especially in times like these where, unfortunately, things may quickly go south for the company, and meeting and discussing and keeping a proper paper trail may be the director's only saving grace from personal liability.
Thanks, Mar. This basically wraps up our assessment of the corporate legal implications related to the board and its meetings. We will now move on to discuss some tax implications. We in fact received some questions from the attendees related to the issue of substance specifically and how this will be affected when remote meetings are held. This is a very topical question. I will leave the discussion in the hands of Dr. Sarah Rousey and Dr. Rebecca Diacono, who I'm sure will explore this and other related matters.
Thank you, Krista, for the introduction. And as you have rightly mentioned, whilst I shall be going into, we shall be looking at the tax side of things now in relation to what all that was said, specifically vis-a-vis substance, because that is the key concern here. And we shall also be addressing during the course of our presentation the questions which have already been put forward. So whilst I shall be going into the general tax principles and giving an overview of same, Rebecca will then step in and will give us sort of the OECD position and the Malta Revenue Department position as to whether any of these general tax principles have been affected and in what way, if so, due to the current COVID-19 situation we are facing. So by way of general overview, the general tax treatment of a Maltese company, just by virtue of the fact of having a company which is incorporated in Malta, such company would be deemed to be resident and domiciled in Malta for tax purposes, and it would also be taxable in Malta on a worldwide basis. This, of course, subject to any double tax treaties and any claims which foreign tax authorities may raise in the light of these double tax treaties, so basing themselves, of course, on the double tax treaty in question, if at all. And the issue of having a double tax treaty coming into play or not would be relevant vis-a-vis the Maltese company. So it would be relevant by, for example, if you would have a board of directors of the Maltese company, which would consist of not only local resident directors, but also foreign non-Malta resident directors. So you would have a mix of directors. Or even maybe the case where you would have simply a board of directors of a Maltese company constituted of non-resident directors. These considerations would not be relevant if we had to be looking at a Malta company which would consist of solely a board of directors who are all residents, local, and which are all currently sitting here. So it is when you have this mix of board of directors which would be relevant in this case. In that case, therefore, a company, just because of the fact that we said that it would be deemed to be taxable in Malta on a worldwide basis, just because of the fact that it's incorporated here, you may have other considerations coming in from a double tax treaty perspective. And that is where we would refer to the double tax treaty provisions. For the purposes of this webinar, we shall be looking at the provisions of the OECD model. So the OECD model is a model upon which double tax treaty provisions are generally based. So generally speaking, all our double tax treaties, their wording is a replica of the OECD model wording. So specifically in relation to this point, if we had to look at Article 4 on residence of the OECD model, this reads that the term resident of a contracting state means any person, in our case, the company, the Malta company, who under the laws of that state is liable to tax therein by reason of his domicile, residence, place of management, or any other criteria of a similar nature. So that is where the term place of management is key, residence, place of management. And what would one consider so as to determine this place of residence, place of management? So typically, one would be expected to take account of a number of factors, such as where the meetings of the company's board of directors are usually held, such as where the chief executive officer and other senior executives usually carry on their activities. Where do the senior day-to-day management of the company, where is it carried on a day-to-day basis? Where are the company's headquarters located? And which country's laws govern the legal status of the company? And where are the accounting records kept? So, you know, a whole series of considerations which one would need to factor in. Also, in the context and against the backdrop of this double tax treaty conversation which we are having, one would also need to consider the notion of permanent establishment. So it's not just residence, it's also permanent establishment. Is a permanent establishment being created in another contracting state? That is key, because if this is the case, then the overseas contracting states would have the right to tax the profits of the multi-enterprise in this case. So again, if we had to look at the wording of Article 5 on permanent establishment, this provides that the term permanent establishment means a fixed place of business through which the business of an enterprise is wholly or partly carried on. The term permanent establishment includes especially a place of management, a branch, an office, and it goes into other examples. So again, if in the example which I have been given, you have one of the directors who is non-Maltese, who is foreign, and he is really and truly the brains behind the business, and is now stuck in a country overseas, and is in the impossibility of traveling to Malta at the moment, then would that constitute a permanent establishment now in whatever country he's sitting in? And these are the questions which now Rebecca shall be addressing as to whether COVID-19 has had an impact on all these notions which I have mentioned. Over to you, Beck.
Sorry, I was on mute. So thank you, Sarah. As Sarah said, obviously, with companies where we have a mixed composition of a board of directors, these considerations have obviously come to light due to COVID-19. Essentially, the OECD thankfully acted quite swiftly, and at the very beginning of April, they issued a policy paper which dealt with various situations arising out of COVID-19. For the purposes of the webinar, we'll focus on three aspects of this policy paper, which is as Sarah said, what happens with effective management and control. We'll then look at the Home Office and agency dependent permanent establishments. So as Sarah said, when you have a situation of a mixed composition of a board, we're always pushing clients and drilling it down their ears that they need to come to Malta, you need to travel to Malta, you need to have your board meetings here. And you need to ensure that you try as much as possible and keep the effective management in Malta. With, COVID hit at a time when we were going into board meeting season, so that obviously didn't help either. And we had to face a situation where meetings had to be held over video call or telephonically and so on. And so in that case, as touched upon before going to the policy paper itself, as Sarah Grima mentioned, one of the main considerations which was faced was, do your M&As actually cater for a situation where you're allowed to hold meetings telephonically? We actually, from our end, from a tax perspective, a lot of our clients actually in their M&As were restricted from holding board meetings telephonically. And one of the main reasons was that we've been trying to drive it into clients that you need to travel to Malta. If your M&As actually restrict telephonic meetings, then it made it quite easy in the sense that you actually have to come to have a board meeting. So we were faced with a situation where we either had to amend the M&As, as Sarah mentioned, or else another option which was also catered for and which is something we implemented, particularly from a tax perspective, which we recommended, was also the possibility that the shareholders would pass a shareholder resolution, which would simply allow the directors to only have board meetings telephonically during the crisis. And this sort of tied into the tax side of things, because with certain clients where we've spent years building up structures, we wanted to avoid a situation where we go back to, you know, stage one, where then they become lazy and they don't travel to Malta anymore for board meetings. So obviously, everyone's getting used to working telephonically and remotely, and there might be a drive for it to become the norm, but you still have to factor in considerations of tax when dealing with this. From an effective management and control perspective, thankfully, the OECD took a good position on it. Obviously, the OECD recognized the fact that it's a crisis. We cannot travel because there are travel restrictions in place. It's not because you are choosing not to travel that you can't travel and hold board meetings, that senior management are stuck in different countries to where they would usually be stuck. So basically, although, yes, typically from an effective management and control perspective, you have to look, as Sarah said, where are the board meetings held, where is senior management held, you know, where is the day-to-day management at a top level happening, and where are the decisions being taken. Now, the OECD, obviously, as Sarah said, when you have the double tax treaties, you would have to look at tiebreaker clauses. In the latest tax treaties, tiebreaker clauses are linked to mutual agreements between member states, which means that if you have a company where there is a concern that the company is dual resident, and which means that potentially that company would be subject to corporate tax in two member states, two contracting states, then you would have to look at the tiebreaker clause. The tiebreaker clause is by mutual agreement, which means that the actual contracting states where there is this claim of dual residency have to agree between them where the effective management and control is. What the OECD has said is that you need to look at what was usually happening. Okay, so was the board traveling to Malta before, you know, the crisis happened? Were decisions being taken in Malta? Was there a level of substance and effective management and control in Malta? So if it had to reach a situation where you go into the tiebreaker clause and you would have mutual agreement, then these would be the considerations which would need to be taken into consideration. Effectively, obviously, what this means, however, is you can't have a situation where you never bothered to come to Malta, you never bothered to have your board meetings here and try and ride the wave of COVID and the OECD policy paper and say, oh, yeah, you know, and the company is resident in Malta. So you still have to look at what was happening before, make sure that, you know, before everything was being done properly, and if everything was being done properly prior to COVID, then based on this policy paper, you shouldn't have many issues to worry about. So from an effective management and control perspective, the OECD said you have to take all facts and circumstances into account, look at what was happening before, and then assess. So in that case, that's quite a good position taken by the OECD. The other thing which the OECD focused on was the Home Office. The Home Office would come into play, for example, you know, where you would have employees in Malta, employed with your Maltese company, and these employees have suddenly all repatriated home, which is what's happened, and are all working across the world in different offices in their home office for the Malta company. Effectively, a home office can constitute a permanent establishment for tax purposes, and this has always been catered for in the commentary of the OECD Model Convention. So it's not something which sort of is invented due to COVID. However, when you look at the concept of the home office, there has to be a degree of permanency in that home office. So was the employee always sitting, for example, in Italy, working for the Malta company? What is the home office available to the enterprise on a regular basis? Or is it just a result of the crisis? So effectively, here again, one has to assess the position they took is similar in the sense that you look at what was happening before. So if it's just, again, due to the government restrictions imposed, you know, certain countries are like Malta, we didn't have a full lockdown. Other countries had a full lockdown. You couldn't go into the office. If you have these types of restrictions imposed, then it's not the enterprise who was imposing it on the employee. You have to work from home in another country. So again, you look at the situation pre-COVID. However, one thing which we have to factor in is now we're all seeing a drive of, oh, let's telework, let's work from home, this is great, it's good for the environment and so on, which those are all considerations which probably we're going to see a change in the way people work. But obviously, if there's going to be a drastic change into the setup of your enterprise and you're going to have people working from home offices globally, then you can't continue relying on COVID post-COVID. So this position paper actually even tells you if this is going to become a new norm, then hey, we have to look at the situation at that point. So it can't carry on forever, and you don't worry at all about whether you do have a permanent establishment through a home office. So we're purely looking at this transitory sort of pandemic stage at the moment. The other thing the OECD went into, which is relevant for today, is the concept of agency-dependent permanent establishment. Again, these are concepts which always existed, but which gave concern due to, again, employees and board members, etc., being stuck in other countries. You would have a dependent permanent agent, basically where you have a situation where someone is habitually concluding contracts on behalf of an enterprise. So, for example, Malta has someone in Italy, again, who is concluding contracts on behalf of the enterprise in Malta. This was always a real concern that had to be considered. But again, the OECD said, if here again, there were travel restrictions, it's very similar to the home office. So travel restrictions, the person wasn't prior to COVID-19 executing and concluding contracts in Italy for the Malta company. It's just a result of the situation. And then here again, the risk of creating a permanent establishment in Italy is low. Of course, you can't just depend on the policy paper, read it and apply it. If you do actually have these types of situations, one should still consider them and assess them on a case-by-case basis. But thankfully, the position adopted by the OECD has been a practical one, and it should, the way they've adopted it and the fact that it's been endorsed by the Maltese Revenue, which is a huge plus, should provide a level of comfort. But as I said, it can't be sort of fully relied upon for Kingdom Come. In fact, my sort of concluding remark, and is something I don't have an answer to, is so now we're looking at a situation where the airports are opening. People can start flying into the country, although from a limited number of countries. What's going to happen in a situation where people can travel, and you can come and have your board meetings here, but I don't want to travel because I'm a vulnerable person, because I just don't feel comfortable. And so in that case, is the OECD position paper still going to stand, or are we going to start looking at a position where the sort of standard tiebreaker clauses, etc., have to be considered without any reliance on the OECD's position paper for COVID? So this is a situation we'll have to follow and see what happens over the next few months.
Thanks, Rebecca and Sarah. So exciting times ahead for you then. Now to conclude our session this morning, as I said earlier, we've invited Carl Diacono and Adrian Merchea to address some questions which will shed light on tangible aspects of acting as director over the past months and possibly also in the next weeks or months ahead. Carl, I'll start off with you. What was perhaps the most challenging aspect of acting as director over the past months?
I act on director on a number of companies, but if I had to, point out, the key issues, I think it is obvious to say that the main concerns of all companies would have been preservation of capital and, cash is king, cash flows. We have been hit unexpectedly, with a pandemic that has, in some cases, locked businesses overnight, where you have very healthy businesses, on a Friday, and the business closed on a Saturday, which overheads that you have to carry, employees that you need to pay, and no revenues coming in. And these businesses vary from, a little restaurant in Valletta. I own one of them, so I was personally hit by that, to some very large entities employing thousands and thousands of people within the hospitality industry. So, whilst we have had crises in the past, the 2008 crash and similar, financial crises, this is something completely new, which has, shocked people. And it took a little bit of time for people to realize, what am I going to do? So I guess the key challenges were and still are, making sure that you save, you preserve your capital, and that cash is king, because you need cash to run your business, and that you do whatever you can to maintain a healthy cash position. Those have been the key concerns, I would say, overarching for all businesses. Obviously, each little different business then has its own challenges, because some businesses did well in COVID. For example, if you have to look at Zoom, they announced their results this week. They had 169% growth in revenue, 254% growth in corporate customers with more than 10 employees, and a phenomenal growth in revenue. Probably their challenge would be, how are they going to manage to maintain that growth post-COVID? Because, once people start going back to the office and they don't require to use Zoom as much as they're using now, that's a different challenge for them, a nice challenge to have. But I would say the key challenge with all the meetings I've had has been, what am I going to do to make sure that my business comes out healthy post this crisis? And that's an ongoing challenge for a lot of people.
Definitely. Adrian, how did meetings of directors and decision-making effectively change for you? Adrian, you're on mute.
The most obvious one was the use of technology. So whilst we are used, as Rebecca was saying, to have meetings predominantly in Malta, to have all the boards traveling here, we were faced with a situation where the board members couldn't travel here. So we needed to adapt to the use of technology, which, besides having its own challenges, we as a board had to ensure that the statute of the company allowed us to use technology, and we had to also look at tax considerations, as previously mentioned by Becky as well. Are we creating a permanent establishment outside of Malta? Is this going to have an impact on the company? So that is the most perhaps identifiable change. But then you'd also have situations where the board was planning a certain route for the company. There was a certain level of growth, and all of a sudden you end up discussing how to mitigate the situation that the company ended up in because of the pandemic. So quite a few challenges, I would say. As well.
Definitely. Carl, how are directors effectively communicating with one another? And we mentioned before the Maltese and non-Maltese directors. Has the communication changed at all during these times?
It's changed in the sense there's much more of it. And what has happened as well, again, because of legalistic reasons in terms of time to set up a board meeting. Is it a board meeting? Is it not a board meeting? We've had a lot of conversations, but then we had to take decisions in the sense of, is this a board meeting? Is it not? Is it just we're sharing information to make sure we're abreast of things? It also depends on the size of the entity, because you can be a director in a company where the directors are effectively the executives and they take executive decisions. But then there are situations where you're a director on a larger entity, you've got management in place that's doing the day-to-day, and as a director, you're there to oversee the executive management. So where you tend to be the executive, there's much more communication because it tends to be a rather small board, and typically you would also see shareholders being part of the board as well. and there the communications is much more personal. You know, today we meet in people's kitchens and people's dining rooms and sometimes in people's bedrooms as well when they want peace and quiet. You know, that's what technology has done to us. We've entered into people's homes on a very regular basis. On the larger entities, it's a bit more formalistic. You still have the meetings and they're still more regular because the issues are of great concern at this point in time. And the discussion is slightly different because, you know, the shareholder is a bit more removed. They tend to be, as I said, larger entities, probably, you know, with global spread, you know, and the decisions are a little bit more confirming or assessing what the executive is doing at this point in time. Obviously, there are concerns that we have mentioned already. You know, you have a healthy company which overnight has serious cash flows issues, which then create solvency issues. So you're looking at ways and means of refinancing, restructuring, you know, to make sure that we come out of this healthy. You know, and we've seen a number of excellent businesses who, within a few weeks, have suffered tremendously. You know, some great brands like the airlines. I don't need to go into detail because everyone sees them in the press. This has been, you know, devastating to large businesses. You know, it's got to be a challenge, I think, for months, if not years to come, for some of these industries. You know, to get back to normal. As directors, there are challenges we need to face, and it's communication is key. We've become a little bit informal in the sense. You know, there are remote meetings. You might not have the company secretary present. Mm-hmm. You might have to do away with notification because, you know, there's a crisis that needs to be handled. You need to get directors on a call. You do it, mm-hmm. and then you decide ex post how to formalize the discussions and the decisions you take.
Exactly.
You know,
in fact,
yeah. So.
You mentioned the company secretary. I was going to ask how important was the company secretary during this time by way of coordination, and did you see the role changing? I don't know, Carl, maybe. And
no. What you see is you literally get a call. You know, a bit of panic. Listen, what are we going to do? And there's no time, as I said, to you know, have a formal board meeting. But you need to take a decision. So you sort of discuss and you say, okay, we had a board meeting, this is the decision we're going to take. You then try to formalize that decision by then calling a board meeting, having it minuted to make sure that that decision is properly recorded. You know, but you know, in crisis, sometimes formalities have to fall a bit on the wayside. Is it legally correct? Perhaps not, but the business needs to take decisions, you know. So, you know, you take the decision and then you do the formalistics later, you know. Mm-hmm. You tend to see this in the smaller businesses. The larger businesses have a structure in place. They've got the support mechanisms in place to be able to make sure that things are done, you know, properly. But, you know, the smaller, mm-hmm. let's call it family-run entity where the shareholder is part of the board, where he needs quick decisions, then it tends to be less formalistic.
Mm-hmm. That's it. Adrian, you actually manage quite a few company secretaries in your offices. How did they react, and how essential did they feel their role was during this time?
Well, I mean, the role of the company secretary per se is a key role, particularly in board meetings, because the responsibility is to ensure that, for example, proper minutes are taken. Now, in these current circumstances, the board's decision could have been extremely important for the well-being and for the continuity of the business. So there, it is key for the company secretary to take proper minutes and to make sure that whatever has been decided during the meeting is properly recorded, because it could have implications, and very important implications, in the future of the company. So you want to have that properly minuted and recorded. Obviously, perhaps even the number of board meetings, whilst during what was the norm, we've had board meetings every quarter, for example. Now we may have had instances where there were board meetings every week, or even more regular than that, because there were important matters to discuss and to resolve on.
Definitely. And in this sort of link to this, speed and presence of mind, do you feel that the pace, how was the pace, and can it be slowed down now that we have this new normal and measures are being eased? Adrian.
Well, it depends. I mean, speed is always essential, and in the particular circumstances that we had, and as Carl was saying before, it was key to take important decisions at the very right time. I feel, though, that the board should still keep on monitoring what's happening, because things might change even now. So it is key for the board to be on ball and to ensure that proper decisions are taken when they need to be taken. What happens going forward, we don't know. I mean, it depends on the business of the company as well. There could be companies where once this pandemic is over, or now that we're seeing the relaxations of measures, it is now the moment for them to step up their game and start taking actions in order not to miss any opportunities.
That's it. Carl, what you mentioned some of this before, but what were the key areas of discussion? I would imagine solvency, but other areas which.
No, definitely. Solvency obviously is always at the back of your mind, because that's a critical issue that has been discussed already by Marie and Sarah and others. There is obviously the business continuity. And again, it depends on which sector you're in. For example, the service sector that we're in, you know, one of the biggest things that we needed to look at was, you know, the offices are going to be, we decided to shut down our office, how we're going to carry on working from home. So, you know, we were lucky that we had investments in technology that has served us well. You know, overnight we had to move, you know, roughly 130 people from the office to the home. So there was, you know, discussion about making sure that works and that gets into place. And once that happened, then making sure that the communication between a dispersed workforce remains strong. So there was that issue as well, you know, managing remotely where you're used to meeting people on a day-to-day basis, you know, patting each other on the back, having teas in the canteen. Now all of a sudden it's all being done as we're doing now. Everything is being done remotely, which is a new way of doing things, and it's a bit difficult to get used to it. So, you know, management styles had to change. So there was a bit of discussion, and there still is discussion in managing that situation. You know, in other businesses or other companies, as I said, the issue of cash flow always remains key. But there's already discussion of what next. You know, post-COVID, what are we going to do with the business? You know, we have you know, some companies where I sit on the board, you know, quite interestingly, COVID has been, as I said, positive for them in the sense, and you know, this is supermarkets. Everyone knows what happened to supermarkets when this all started. You know, everybody, you know, thought that toilet paper is the best thing in the world. You know, that particular industry all of a sudden has found itself in a completely different situation to where it was, you know, a few months ago. And now we're saying, listen, what can I do, you know, to carry on making sure I ride on this wave? You know, so looking at strategies to make sure that you know, post-COVID, you maintain the clients that you brought in, you know, through this client. So it was quite an interesting mix of discussions. You know, some businesses, I said, did well, so it's particular discussions. Other businesses, solvency issues, so different discussions. And the other is, you know, maintaining the business that I have today, because I can offer services remotely using technology, etc., and making sure then I use the lessons that I'm learning today to make my business better in the future. You know, so again, depending what business I am in, the discussion around the table is extremely different, which makes my life extremely interesting as well.
There definitely is discussion going on.
There is a lot of it, and extremely varied, as I said. You know, it really depends the situation of the entity.
That's it. What about the authorities? Do you feel they were quick to act, flexible? Do you think they need to step up? I don't know. We're in contact with the MBR and...
Yeah. Okay. Locally, I think they started a bit slow. They realized very quickly that what they offered at the first package was not enough, and they were quick to react to that. They listened to industry and they reacted to that. They haven't covered all industries, you know, but I don't think we should expect government to be able to support everyone. I don't think there's the money to do it, you know, but they let's say they're doing their best. We have a budget coming out again now, which I'm looking forward to listen to, you know, because we are going to need support. When I say we, the economy generally and more the industry generally, because this is going to affect us for the long term. You know, motor is highly dependent on tourism. we've been saying, and we've been listening to people within the industry saying that's going to take 3 years to come back, you know, it's going to hurt us, you know, so there's going to be need of support from government, and the money's going to need to come from somewhere, and eventually that money's going to have to be paid back, you know, so there's a lot that's going to happen over the next few years that industry needs to be prepared for. You can't just expect help and then not expect to pay back for that help that you got. So there's going to be a quid pro quo eventually for all of this. You know, the authorities are doing their best, you know, and you know, I don't think they could do more given, or rather they could do more, but where's the money going to come from?
Yes.
You know, that's the issue that we need to look at this point in time.
That's it. To conclude, Adrian, what does the future boardroom look like? Is it any different to what we know?
Well, we've seen now that the technology is there to help us. So board meetings are being held, perhaps faster to organize, faster to take decisions, and we've seen that it works well. I would hope that the world has seen the advantage in this, and going forward, if not, I mean, I don't expect the physical board meetings to end, but at least a shift towards using technology to help us a bit more. Exactly. One will have to wait and see, though.
Yes.
Always bearing in mind if tax substance issues allow us to do so, because then obviously there's that issue as well.
That's it. But maybe it can add communication as well, you know, whereas we would meet maybe a couple of times, now we can meet even more often, not necessarily in Malta only. Okay. Yep. So thank you, Adrian and Carl, for very, very informative feedback and insights. Unfortunately, I'm seeing that time has run out for us today. As explained earlier, feel free to contact us directly. We'll do our best to get back in touch with you in the coming days with some sort of feedback, and we'll be in touch. So this brings us to the end of our webinar today. I hope that you were able to take a few useful tips and bits of information with you to help you in the current climate and hopefully to ease your business and your job. Someone once said that knowing what must be done does away with fear. We definitely have all faced the fear of the unknown in the past months in some way or another. However, this could possibly be taken as an opportunity for directors in particular to work outside their comfort zone and possibly emerge as even more successful should they manage to help their companies weather the storm. On that note, on behalf of all the panelists today, I'd like to thank you for attending this session. And in the meantime, we obviously wish you a good day and hope you'll be able to join us for another Fenech and Fenech webinar in the coming days and weeks. Thank you.